Good afternoon. My name is Tim Lynch. I am your host of Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. We are live the third Wednesday of every month at this time, 4 p.m. And Legal Lines, as I always like to say, is an award-winning show thanks to our good friends at B&N. Our guest here today is my good friend Ben Klien from GLAAD, and we're going to be talking about a legal issue that's been making the news, religious exceptionalism. Ben is going to talk about a case he's handling, and we're going to talk a little bit about the recent Supreme Court decision in the Hobby Lobby case. Ben, how are you?
Good, Tim. Happy to be here.
Well, it's good to have you. First of all, you're from GLAAD. And
Correct.
if you can tell our viewers what GLAAD is and what GLAAD does.
Sure. Well, GLAAD is Gay and Lesbian Advocates and Defenders, and we are a legal organization that fights for the rights of lesbian, gay, bisexual, and transgender people and people with HIV throughout New England. So mostly we work through the courts, handling civil rights and discrimination cases, but also do a fair amount of legislative and policy work here in New England and nationally to some extent also.
Yes, and you do, and to put more of a fine point on it, you guys are the ones that won their first marriage case here in Massachusetts.
That's right.
Yes, and
10 years.
10 years. 10 years ago, and now, what are we at, 21 states?
I think it's about 25 or 26 states.
Oh, yeah. Well, they keep, there's so many, they keep going.
Yeah,
God bless them. Good.
Yeah.
So, okay, but you're here today to talk about a particular case you're handling, dealing with this religious exceptionalism issue. Perhaps the best way to talk about it is to talk about your case a little bit and then describe for the audience what exactly this is all about.
Sure. Well, we are seeing, I think, an increase in the number of instances throughout the country where religiously affiliated institutions, particularly schools, are firing employees who are in a same-sex marriage, and that's creating a lot of issues around how we balance in our society two very important ideals, and one is religious liberty, but the other is non-discrimination and equal opportunity, the right to work and the right to live in society free of discrimination, and we're seeing these cases come up quite a bit. And we have one here in Massachusetts that is going to be working its way throughout our courts. And just to give a little concrete example to the viewers, that is a case called Barrett versus Fontbonne Academy. It's a very simple case. Our client had over 20 years experience in the food services industry, and so he applied for a job at Fontbonne Academy to be the food services director. He was going to cook the breakfast and lunch for the students and oversee all of that operation. He applied for the job. He had 3 interviews. They loved him. He had great experience, and so of course they offered him the job. In fact, they pursued him quite aggressively. And he came in, and as frequently happens on when you've accepted a job offer, they have you fill out all kinds of forms, and one of them asks for your emergency contact. And so he fills out the name of his emergency contact, and then they ask for the relationship of that person to you. And he writes husband, and he goes home and he gives his notice to his prior job, and he's really excited. And a day later, he gets an email from the school. Please come in. We have some issues with your employment. And as a result of disclosing that he is a man who has a husband, they terminated his employment.
Wow.
And so the facts are very simple. And this is coming up again across the country. We've seen in the past couple of years, I'd say probably 20 to 30 examples of guidance counselors and teachers and coaches being fired by schools because they're married to someone of the same sex. These are religiously affiliated schools. And so I think what we're seeing is a real shift in our society. I mean, generally, we have had a very careful balance between religious liberty and non-discrimination. And when we look back to the Supreme Court cases around religious liberty and the First Amendment of the 70s and 80s, we see very different kinds of cases, because those cases were really about protecting minority religions in American culture. So there were cases, for example, where a Seventh-day Adventist would not work on Saturday. the Sabbath, and that person was denied unemployment benefits. And the Supreme Court said, no, that's an infringement on his religious liberty. There was a very famous case, Wisconsin v. Yoder, where there were criminal sanctions imposed against an Amish family that, because their religious belief was we don't send children to secular schools, we do homeschooling, and it's a very agriculture-based education. And the Supreme Court said, no, you can't punish a minority religion in that kind of way when there's no legitimate governmental interest. They can educate their children at home. We are seeing something very different today. It's no longer about protecting minority religions. What we are really seeing is that as we have advances in rights of lesbian and gay people, particularly around marriage, but also around non-discrimination laws, which more states are having, we are seeing the pushback come from religiously affiliated entities that are trying to tip the balance more towards being able to discriminate against gay and lesbian people. And that's a very dangerous thing when we start opening up exemptions to basic non-discrimination laws that apply to everybody. And we're really shifting the balance in favor of discrimination in those instances. We obviously saw it in the U.S. Supreme Court, where the other area we're seeing these religious objections is in the area of contraception and women's reproductive rights. One of the things in our case that's really notable, and I think that's the key fact in our case, is that this person's job had nothing to do with religion. He was being hired to cook lunch.
Yeah.
And it's not a case, there are protections when someone is in a position as a minister or in a minister-like position. So for example, if you're teaching religious values, there are exemptions there. But this is somebody who had no role in teaching religion or in the religious life of the school.
No, it's just food.
Right, right.
So, and the children wouldn't really interact with him either, wouldn't think very much.
Well, there might be some interaction because, it's a school and he might be in the food line and there might be some conversation, but his job is not about teaching religion or religious values. And so it would, these cases are just starting to be litigated, and they're going to be arguments that the school is going to make. But it would be, in my view, quite dangerous if somebody who, if a school could refuse to hire somebody who had nothing to do with religion based on some kind of religious objection. That would really be shifting the line between religious liberty and non-discrimination.
So, and you're saying the line is okay when it's, when it deals with somebody who's teaching the general philosophy or theory,
right,
and a minister or a religious teacher.
That's right.
But the line gets crossed with we're a math teacher?
Yes, so there's actually a doctrine that courts have developed called a ministerial exception. And that's for employment discrimination cases. So schools cannot, and other religiously affiliated institutions cannot be sued under either federal non-discrimination laws or state laws like Massachusetts has that protect on the basis of a number of grounds, sex and race and disability, and including sexual orientation and gender identity. They can't be sued if the person is a minister. And that's not limited literally to ministers. It's to anybody whose job is part of the pastoral mission of the school. So if you're teaching religion, if you're a pastoral counselor, and you're fired, the First Amendment says we can't touch that because that's related to the religious mission. But if you're a math teacher or a basketball coach or a food services director, then in our balancing between non-discrimination and religious liberty, the law is and should stay on the side of promoting equal opportunity for that person. So in our history, religious liberty's never been absolute. We're always balancing, when should a religious entity get to ignore the laws that apply to everybody else, and that's the balancing we're talking about here.
Okay, and how does, there are other cases, this is one group of cases, how does it relate, or does it relate at all, to cases where we've heard of, although I tend to think this must be a rare occurrence, where people say they've been sued because they're a florist or they're a baker, and they don't want to cater to a gay wedding. You know, I have trouble with this because who in their right mind has a wedding and then wants to have a baker or a florist who would be hostile?
Right.
You know,
well,
to them, that's your big day. You're not going to hire those
But the real issue there
people,
isn't, you know, maybe somebody wouldn't want to go to a hostile business, but the really important issue there is, you know, our law should set the standard for what is correct and what is permissible. And those cases do relate. So just like we have laws that prohibit discrimination in employment, we also have laws that prohibit discrimination in businesses. We call them public accommodations. So those are any businesses that are open to the public, and anybody can walk in and order a cake or go to an inn or have a photographer for your wedding. And there have been some of those cases. There have been cases where, you know, the baker won't make a cake for the same-sex couple's wedding, or the photographer won't do it, or the inn won't rent out their space. And in those cases, there have just been a few to date. We've been largely successful in those because in these instances, just like in the employment context, you have a commercial entity. They have entered the marketplace of society, and in order to engage in commerce and make money, and just like, you know, it was very clear, you know, under race discrimination laws that you can't discriminate on that basis, and we had a lot of those cases in our country's history. The same principles are coming up here, that if you enter commerce, you cannot deny somebody the opportunity to participate in your business solely based on protected class status, whether it's race or disability or sexual orientation. There was actually a case that went to the New Mexico Supreme Court with a photographer who would not want to provide services to photograph a wedding of the same-sex couple. And the New Mexico Supreme Court said that's not permissible. That case had a public accommodations theory, but also had this First Amendment theory where the photographer was claiming this was protected speech, and that was forcing her to engage in speech she didn't want to, and that theory was rejected. So there have been a number of cases in New England. There was a case in Vermont with an inn that didn't want to photograph or didn't want to host a wedding, and that case was settled. So a lot of these cases are settling, very few of them, but some have gone to court. But these are principles that, you know, we wouldn't be, and it's really demonstrating the shift in
social values,
and where this area is, because if we, you know, if you had a business today that said, you know, we're not going to host an interracial marriage at our inn or at our hall. Nobody today would think that that's a close question under our non-discrimination law. But there are people now pushing that theory for sexual orientation discrimination. And the sad thing is that in some quarters it's seen as a legitimate legal issue we have to you know, wrestle with, when in fact it really should be a settled law. Absolutely.
People shouldn't be allowed to discriminate when you enter the free market.
That's right.
Period. Full stop.
That's right.
Yes, and because of the tremendous harm that is caused by such discrimination, and it would be uncontrollable once people are able to say, well, I don't want to do business with this religious group, with the, you know.
That's right.
Where is this ever going to end?
Yeah, and I think that once people really think through the slippery slope of discrimination, I remember being in Connecticut and testifying at a legislative hearing where one of these bills was before the committee, and there was when
you say one of these bills, you mean?
A bill to allow exemptions for religious and for people to refuse services to gay and lesbian people on religious grounds.
Wow.
You know, and I remember a fairly conservative Catholic legislator was really agitated about this, because he said, I remember times when businesses would not serve Catholics and where Protestants discriminated against Catholics.
Yes.
And are we going to go back to that point in our history and open that up again? But that's what we'd be doing, you know, by really shifting the balance between religious liberty and discrimination.